As Britain battles its third lockdown and businesses seek to cope with all the disruption caused by the lockdowns, there is ripe ground for disputes between different parties. This podcast is going to focus on mediation as one particular way in which disputes can be resolved. My name is Zara Hussain and I'm a partner in the Litigation and Dispute Resolution Department of Edwin Co. In this podcast, I'm going to be discussing what mediation is and how it works, the various advantages of embarking on the mediation process, and I'll also be considering some of the potential disadvantages of going down the route of mediation. When we faced our first lockdown in Britain almost a year ago, Lord Neuberger, who is the former president of the Supreme Court, expressed the view that there could potentially be an avalanche of litigation flowing from the situation involving COVID-19 because of the contractual breaches and non-performance of contractual obligations that may occur because of the disruption caused by the virus. Lord Neuberger suggested that one way to try and avoid a deluge of cases being filed in court would be for the parties to consider mediation before issuing a claim. As businesses look to recoup the losses that they have suffered, thanks to the tumultuous year or so that we have all suffered from, the need for dispute resolution becomes all the more pressing. Mediation has always been an option open to parties. Indeed, it is something which is encouraged by the courts, and it should always be considered by potential litigants. Mediation is, however, often only explored after a claim has been issued. In this podcast, I will be examining why it might be sensible to consider mediation before a claim is actually issued at court. So what is mediation? Mediation is a confidential procedure in which a third party, who is completely independent of all those involved in the litigation or potential litigation, assists the parties in trying to reach a settlement. The mediator does not act as a judge. His or her role is to seek to resolve the differences between the parties by settlement. Mediation is usually a voluntary process in which the parties choose to partake, unless there happens to be a clause in the relevant contract or the contractual documents which requires the parties to mediate. The mediator is neutral and will usually start the day by speaking to each of the parties separately. There will often be what's called an open session involving all parties, in which each side is given the opportunity to make an opening statement. After the open session has finished, the parties will each have private and confidential meetings with the mediator. If the mediator thinks that it would assist, a further joint meeting may also be held. Any settlement which is reached at the end of the mediation, or sometimes in the days and weeks that follow it, is binding on the parties by virtue of the settlement agreement terms. Moving on now to some of the advantages of mediation. Well, generally speaking, mediation is less expensive than issuing a claim at court. Depending on the value of the claim, the mediator's fees tend to be less than the fee that a claimant would pay to have to issue a claim in the courts. The costs are also normally split equally between the different sides. If the mediation goes well, it can produce a speedy resolution of the dispute and save on all the other litigation costs. The process may also assist in preserving any ongoing relationships between the parties, as it is less aggressive than initiating a court claim. Due to the fact that the mediation process is private, it can be very attractive should the dispute give rise to any sensitive or confidential issues. It's also a less formal forum than a courtroom in which to air and try and resolve issues. In this current climate, mediations can be held via conference and call facilities too. Turning now to some of the disadvantages of the mediation process. Well, first of all, as you can probably imagine, it requires cooperation and a genuine buy-in to the process on all sides. everyone needs to work together towards finding a resolution. Sometimes tempers can flare on the day, and parties may find that the amount of waiting involved as the mediator moves from one side to the other can test their patience. Similarly, sometimes parties find that they want their day in court, and if so, mediation may not be suitable. There may also be some disputes in which going public brings a discernible advantage, in which case the confidentiality of the mediation process may not be desirable. The lack of formal rules for the process can also sometimes result in an impasse between the parties, unless an adept mediator is being used. One substantial disadvantage of mediation is that if it does not result in resolution of the claim, the costs of the mediation are spent and the case may end up in court anyway. In addition, the mediation costs may not ultimately be recoverable even if you do go on to win the case at trial, because they are usually split between the parties in the mediation agreement and the court will not make a different order. Subject to the type and value of the claim, however, mediation can be a very effective and economic settlement tool. So, if you are considering mediation or indeed litigation, please get in touch with Edwin Co. so that we can discuss with you whether it would be suitable to embark on the mediation process subject to the type of dispute that you're involved in. Mediation might be the best option for you. Please contact us here as we have extensive experience of mediation and we are very well placed to make recommendations regarding effective mediators and to provide with assistance on the day and to advise you as to how best to present your case in front of the other side and to the mediator.